For orders, scene number 1, Shilpa S. Gogi.
May I please, my lords? I appear for a petitioner, my lords. There is a delay insofar as filing of this writ petition. After writ petition, my lords, we have challenged before the Honorable Apex Court in SLP, where, my lords, liberty has given to file a appropriate the authority, my
He
lords.
went on leave on 24/7 to.
On that day, my lords, there is a heat conversation took place between the BO and the teacher, my lords, and forced him to resign for the post, my lords. My lords, 2008, my lords. I apologize, my lords.
2008,
8, my lords.
not 11.
Yes, my lords. Thereafter, he was giving representation to join, my lords. On 7/12/2011, my lords, there is a heat conversation took place, my lords, and forced him to, my lords, give the resignation. And on 16, my lords, 16/11/2013, he gave a representation saying, my lords,
Yes.
cons-
As
as an assistant teacher.
and
And posted-
probation is declared on
Declared on, my lords, 25/4/2006.
then he
He went on medical leave, my lords.
medical leave
Yes, my lords. In
on
24/7/2006. Went on. And my lords reported 2008, my lords.
medical leave was in your account. What was the quantum of medical leave available?
As on that date, my lords, he exceeded that, my lords. It is admitted that after the probationer declared, he went, my lords,
Returned
for
on
a long leave.
7/12/2008.
Yes, my lords. On, my
When
lords,
did he apply for resignation?
7/12/2011 is the date resignation he has given, my lords, not the report, my lords. In the year 2008, he wanted 16/11/2013. 16/11/2013. 16/11/13. On this basis, my lords.
Then what is that representation?
My lords, representation is at page number 73, my lords.
73.
Yes, my lords. In this representation, my lords, the copies we have not referred here, but the one which we have got from the RTI, my lords, because on that day I have given a two representation. One stating that, my lords, kindly consider for the accept my withdrawal, my lords, saying that I have given this. Same day, my lords, another representation annexing the withdrawal, my lords, I have produced. That, my lords, may I permit to file, my lords, along with under order 41, rule 27, my lords. Apex Court, that I have annexed along with, my lords, page number 105 and 106, my lords. Translated copy. 106
ಈಗ
is
review the
the order portion, my lords. What the Honorable keep the order portion, my lords. What the Honorable Court construed, my lords. Last para.
No, you were
two
mentioning 2013 representation.
Yes, my lords.
What is that prayer you have made in the representation?
Representation, pardon, my lords.
2013, you said you had given a representation in 2013.
Yes, my lords.
What for?
That to consider my withdrawal, which I have placed, my lords. Earlier on that day, my lords itself.
After
But
acceptance.
yes, my lords. On the same day of the resignation, I have given the withdrawal that has to be accepted. Saying that, my lords, I have given.
That does not generate confidence
Yes,
because.
yes, ma'am.
Kindly come to
Yes, ma'am.
page 20.
73.
No. 73. Come to 75.
70. Yes.
This is 2036, 11, 2013.
Yes, yes, ma'am.
Okay.
Yes.
You had applied for resignation 12/2011.
Yes.
All right. And you also say that you had given the application for withdrawal of your application.
Yes.
On the same.
ಒತ್ತಡ ಮತ್ತು ಆತಂಕದಲ್ಲಿದ್ದೆ. ಆತಂಕ ಮತ್ತು ಒತ್ತಡ ಮತ್ತು ಆತಂಕದಲ್ಲಿದ್ದೆ. ಆತಂಕ ಮತ್ತು ಬಾಹ್ಯ ಒತ್ತಡವಿತ್ತು. ಆತಂಕ ಮತ್ತು ಖಿನ್ನತೆ, ಎಂಸೈಟಿ, ಡಿಪ್ರೆಷನ್ ಇಂದ ಮಾನಸಿಕವಾಗಿ ಅನಾರೋಗ್ಯವನ್ನು ಹೊಂದಿದ್ದೆ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಸರಿಯಾದ ನಿರ್ಧಾರವನ್ನು ತೆಗೆದುಕೊಳ್ಳಲು ಸ್ಥಿತಿಯಲ್ಲಿ ಇರಲಿಲ್ಲ.
ಮುಂದಿನ ಓದ್ಬೇಕು.
ಎಸ್, ನಾನು ಮಾನಸಿಕ ಅನಾರೋಗ್ಯ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಂಡಿದ್ದೆ.
ಚಿಕಿತ್ಸೆ ಯಾವಾಗ ಪಡ್ಕೊಂಡ ಇವನು?
ಮೈ ಲೋರ್ಡ್ಸ್
ಪಡೆದುಕೊಂಡಿದ್ದು ಈಗ ನಾನು ಮಾನಸಿಕವಾಗಿ ಆರೋಗ್ಯವಾಗಿದ್ದೇನೆ.
ಎಸ್.
ಅವತ್ತೇ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ರೆಸಿಗ್ನೇಷನ್ ಕೊಡ್ತಾನೆ, ಅವತ್ತೇ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ವಿಡ್ರಾವಲ್ ಕೊಡ್ತಾನ. ಮೆಡಿಕೇಶನ್ ಯಾವಾಗ ಆಯ್ತು ಇವನಿಗೆ? His contention that he withdrew his application for resignation same day is a white lie, because in your representation said ಆ ಟೈಮ್ ನಲ್ಲಿ ಡಿಪ್ರೆಷನ್ ಎಂಗ್ಸೈಟಿ ಇತ್ತು, ಏನೋ ಒಂದು ಆವೇಶದಲ್ಲಿ ನಾನು ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟೆ, ಆದ್ರೆ ಆಮೇಲೆ ನಾನು ಮೆಡಿಕೇಶನ್ ಮಾಡ್ಕೊಂಡೆ, ತಲೆ ನೆಟ್ಗಾಯ್ತು, ಅದಾದ್ಮೇಲೆ ನಾ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟೆ ಅಂತ ಇಲ್ಲಿ ಬರ್ದಿರಿ. ಒಂದೇ ದಿವಸದಾಗ ಆಗಲ್ಲ ಅದು. ಮಾರ್ನಿಂಗ್ ತಲೆ ನೆಟ್ಟಂಗಾಗಿ ಮಧ್ಯಾಹ್ನ ಔಷಧಿ ತಗೊಂಡು ತಲೆ ನೆಟ್ಟಗಾಗಲ್ಲ. ಪ್ರೋಗ್ರೆಸಿವ್
ಡಿಸೀಜಸ್ ಕೊಟ್ಟಿದ್ದು 1 ವರ್ಷ ಆದ ನಂತರ. ಇದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿರೋದು 1 ವರ್ಷ ಆದ ನಂತರ 2013.
Correct.
That, my lords, I would
100%.
Yes, my lords.
This is true.
Subsequently, I have.
He has given.
Yes, my lords.
This is true.
Subsequently, I have.
He has given. If a madman makes an application in the morning, in the afternoon he makes another application to withdraw the same application. He is a madman only. Lunatic only. Even lunacy intervals he does not have.
Yes.
So he says, I took medication. Where did he take that? Which psychiatrist? Where? What are the medicines? How long?
So
what was the disease? How he got it cured? When he became sane?
Yes. Yes, yes.
We are not here to decide Lord McNaughton's rule of insanity, legal insanity.
Annexure A1, my lord. Same day representation. One more representation.
Representation.
The
law on the point.
Illenide, my lord, sir. Same day on 6/13 only. This representation, which he is supposed to file before the honorable court, because on that day, my lords, 2 representation he has made. One, my lords, which we have filed before this court, my lords, that is there. On the same day, my lords, he has given.
He will give morning, same day application plus withdrawal application.
Adu 7.
Morning marriage, evening divorce. How is it possible?
Yes, 2011. This representation, my lords, the only court has considered that.
RTI ಮಾಡಿದ್ರೆ ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಇಡಿಸಿರಿ ಒಬ್ಬರ ಕೈಯಿಂದ RTI ಮಾಡಿದಾಗ ಅದನ್ನೆಲ್ಲ ಕೊಟ್ಟಾರೆ ನಿಮಗೆ ಅಷ್ಟೇ. How? We have never read one single case.
It has been allowed.
Allowed in the sense, what is the order?
Saying that, my lords, a petition is allowed, and my lords, saying that, my lords,
instead of acceptance
of resignation effect from 8 November 2008 is required to be modified. That is the date when he tried to report duty, my lords. Accordingly, it is modified, and for the purpose of acceptance of resignation, the effective date is only from the date of acceptance. So that is from 13th February 2012. With this modification, the order of tribunal stands modified, my lords. In the result, writ petition is allowed. So, my lords, in that sense, it has been allowed. But in the para 4, my lords, may I permit to read, my lords? Heard the learned counsel for the parties. First of all, the acceptance of the resignation under Rule 250, 52 1C of rules does not exist in the rules. Subclause C of sub-rule 1 of 252 of the rules was deleted by notification dated 15th November 1980.
Yes.
With the effect from 27th November 1980. Non-existent provision has been referred for the purpose of acceptance of resignation, which is contrary to law and also arbitrary on the part of the respondent. Secondly, when the resignation letter, my lords, but quoting that provision, my lords.
So you mean to say,
My lords, but quoting that provision, my lords.
so you mean to say, in the absence of a rule providing for acceptance of resignation, there cannot be resignation at all. Apex court said wrong,
My
exactly
lords,
contrary.
in the Moola
No rules are required.
My lords, for proper procedure, my lords, with regard to notice or the communication and whether letter of withdrawal not mentioned in those orders, my lords, simply, my lords, accepting that with the, in saying, with referring that rule, my lords. And subsequently, my lords, ಅಂಗೀಕರಿಸಲಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಮತ್ತೊಂದು 97 ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ, mentioning the rule, my lords. That
Appears
is
to be
in
very
so far, my
intrigued.
lords, suspension and dismissal and removal, my lords. So far as rule 97 is concerned, my lord. So far as this 252, my lords, it is non-existence one side, my lords. Another side, my lords, my contention before this honorable court is to quash the acceptance of resignation. But here, my lords, lordship has rightly said, in the last portion, my lords, even in the first para of last line, my lords, challenging the order of acceptance of resignation from the anti-date, my lords.
Effective date is altered.
Alla,
That is
anti-date
May
anta,
13 to
only in
2012.
that sense we have approached this honorable court anta heli ಅವರು consider ಮಾಡಿರೋದು.
February 2004.
February
Thereafter,
2004.
February 2004. February 2004.
February
Thereafter,
2004.
February 2004.
As assistant teacher.
Please. Thereafter, in April 2006, probation is declared.
Correct.
July 2006, he says, I got sanctioned for leave because I was suffering from illness. For what period the leave was sanctioned, nothing is mentioned in the pleadings.
What illness he had?
That is not mentioned in the pleadings, my lord. Thereafter, in 2008, my lord, it is said that this is the finding of the tribunal.
He returned.
The 2008 date nowhere is not mentioned anywhere in the application. The finding of the tribunal is he remains absent from 2008. So going by the facts available on record, my lord, he may have leave from 2006 till 2008, perhaps. That is
How
also
much
not
leave?
clear. That is nowhere forthcoming from the pleadings.
No, how can he earn so much medical leave from February 2004 to July 2006? Can he earn
Nothing-
2.5
nothing is-
years of medical leave?
Nothing is forthcoming from the pleadings, my lord. He says, I was ill in July 2006. May I just finish the facts, my lord? Thereafter, in 2000, the finding of the tribunal is he has remained absent from 2008, my lord. 8, in so far as KCSR is concerned, my lord, there is from some provisions deal with resignation part. However, there is nothing relating to acceptance of resignation, my lord.
No,
In
you
fact,
can't
that is
accept
also
it.
noticed by the tribunal.
That's true. You can't accept. See, power to appoint includes power to determine the
Coextensive with
services.
the power to.
That determination may be by termination or by acceptance of resignation, abandonment. These are the modes which standard books on service law, labor law will say. Okay, he applied. You could have within reasonable period accepted it. But you accepted it with a lot of delay, which always your government will do. Not very,
And with retrospective effect.
to make retrospective effect. Retrospective effect is an attribute of legislative body. Nobody can do that. Only legislature can say with retrospective effect, you are like that, that way. That is an
To
attribute.
that
of
extent, the High
legislature.
Court corrected the order
That
of the
corrected
tribunal.
the date of
From the
effect-
date you
efficacy.
accepted the resignation, only from that, the acceptance will be effective from the date it is accepted. That is all the correction that is made by the High Court.
My lord, sir, no, no,
The lessons a teacher will give.
true, my lords,
If he abandons the lessons a teacher will give,
true, my lords.
if he abandons the class and goes, admittedly, from 24/7 2006 to 7/12 2008, what should happen to the children?
True, my lord.
Should he not have responsibility? So many children are there. They are waiting for taking lesson from me. It's better that they did not take his lessons from him is another thing. But at least at his own level. Suppose if a judge goes without informing anybody,
Yes,
and after 2.5 years, he will come back to sit here, what will you do? Is it not? Simple things we are asking.
yes, my
He is a teacher.
teacher.
The nation is built by the teachers.
Yes, my
And
lord.
all his students would have become like him only. Fortunately, he was away, he is kept away. Therefore, children,
The
at least they have not
circumstances,
drawn
my
those
lord,
lessons.
circumstances which
What
my lords
circumstances?
might have
A person
taken,
who
my
is
lord.
appointed as an assistant teacher in 2004,
Yes,
he gets a confirmation in April 2006.
yes, my lord.
In 2000,
Yes, my lord.
in 2006, July, that is perhaps the confirmation order, ink on the order was not yet dried. Then 24/7 he runs away,
They would have.
and one fine day he returns on 7/12/2008 after.
And for that, my lords, he is not, my lords, insofar as if he's received any monetary benefit in those periods.
He had he
that
worked,
is
he would
also-
have got no
ಅಲ್ಲ ಅಲ್ಲ
wages,
ಅದಾದ್ಮೇಲೆ
no work, no pay.
ಇಲ್ಲ ಅದು ನಮ್ಗೆ
ಬಂದಿದೆ.
ಇಲ್ಲ ಇಲ್ಲ ತಗೊಳಂಗಿಲ್ಲ. Will ready to my lords give back if he has received also.
So we
my
are not ready to take
my
such
lords,
person
one
to the school.
opportunity.
It will be disaster to the school
My lords, one opportunity so
for
that my
spoiling the
lords
children.
No, my lords, by this time, my lords, for these long periods, he understood what the mistake he has done, my lords, that itself is an, my lords.
No
he is a
unworthy teacher should enter the classroom, because classroom is the factory of the nation. Children are born there.
My lords, insofar as
Not for
teaching
such
is
people.
concerned, my
ಯಾವ್ದೋ
lords,
FDC,
probationary
ಯಾವ್ದೋ
declare,
KSRTC ಬಸ್ ಡ್ರೈವರ್ ಯಾರು ಹೋಗಪ್ಪ ಹತ್ಕೊಂಡು ಹೋಗಿ ಏನಾಗಲ್ಲ.
probationary declare satisfaction ಆಗಿದೆ. Insofar
ಅದಾದ್ಮೇಲೆ
as
ಹಿಂಗ್ ಮಾಡಿದ್ದೀವಿ.
teaching is concerned, the way, my lords, he took a leave, my lords, and he's not come in time, my lords.
You
That
are-
in time, my lords,
You
that
are a
we
very-
accept, my
You are
lords.
a very persuasive advocate, we know. But still,
No, my lords, in other angle,
in
my
fact,
lords.
you should have become a teacher. At least in law school.
My lords,
We will never do that sin.
only, my lords,
We will never do that sin.
only
ಇದು
thing,
allotment of site ಅಲ್ಲ.
my,
You want to impose such a man on the children.
if it is reviewed, my lords, if
Will you send your children to a school where he will be a teacher? Answer this.
ನಾನ್ ಹೇಳ್ತಿರೋದು
Nobody will.
once writ petition ಅಲ್ಲಿ ಡಿಸೈಡ್
No,
ಆಗ್ಲಿ ಅಂತ.
no, no. We had
Opportunity to,
great
my lords.
teachers like Gopal Krishna Gokhale, who was teaching about ship. He himself had never seen. He applied for leave.
Yes.
He went to Bombay. He took permission of the pilot of the ship, saw the entire ship, came back and took class to the children. Children asked, why did you apply for leave yesterday? Yesterday I went to the port to see the ship because I have to give lesson today.
Yes,
They are the nation builders,
true.
not these kind of people.
My lords, I
Not
have,
226, so these are not meant for these people. We are astonished that the division bench granted relief. We have dismissed it with caution.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ
ಏನಾಗಿಲ್ಲ.
ಅಲ್ಲ
ಎಲ್ಲ ಆಗಿದೆ,
16
exactly.
2013 ಅಲ್ಲಿ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್, my lords, my lords, my lords, there is a no, not a single black mark on when he is
What kind of black mark? Everything whole, black hole.
my lords, here the status of mind would be seen, my lords, on 13 one representation which given on the same day another representation, my lords.
Namaste, brother. Namaste. Ha.
Reporting settlement, serial number 1, Sumitra.
Reporting settlement. Settlement ಆಗಿದೆಯಾ? Reporting settlement. Settlement ಆಗಿದೆಯಾ? ಏನೇನ್ ಮಾಡಿರಿ?
Full deterioration ಕೊಡಿ ಅಂತ ಟೈಟ್ಲ್. Now they have compromised. 20 lakhs ಒಪ್ಪಿದ್ರು. 20 lakhs
20 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡಬೇಕು.
ನಾನು ಕೊಡ್ತಾ ಇದ್ದೆ.
ನೀವು ಕೊಡಬೇಕು. ಬಟ್ ಆಯ್ತು. ಡಿಡಿ ತಂದಿರಾ? ಬ್ರದರ್, they want to compromise the.
Yes, sir. Yes, sir.
ಅದು suit for declaration.
Yes, sir. Yes, sir. We remember this. I recollect.
ತಾವು ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರಿ ಸರ್.
ಮಾಡಿದ್ರಲ್ಲ?
ಮಾಡಿದ್ರಿ, ತಾವು ಮಾಡಿದ್ರಿ.
ಯಾರ್ಯಾರು ಸೈನ್ ಮಾಡಿದ್ದಾರೆ ಇದಕ್ಕೆ?
6 ಜನ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ ಅಪಲೆಂಟ್.
ಕಮಲಮ್ಮ ಯಾರು? ಕೂತ್ಕೊಳ್ಳಿ. ಆಮೇಲೆ ಕಮಲಮ್ಮ ಒಂದು ಓದ್ಲಿಕ್ಕೆ ಬರುತ್ತೆ ಇದರಲ್ಲಿ, ಉಳಿದದ್ದು ಯಾವುದು ಓದ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಯಾರ್ಯಾರು ಇವರು?
ವಿಜಯ್ ಕುಮಾರ್ ಸರ್. ವಿಜಯ್ ಕುಮಾರ್.
ವಿಜಯ್ ಕುಮಾರ್. ಯಾರು ವಿಜಯ್ ಕುಮಾರ್? ಏನ್ ಮಾಡ್ತೀರಿ ವಿಜಯ್ ಕುಮಾರ್? ಪ್ರಿಂಟಿಂಗ್ ಪ್ರೆಸ್ ಇದೆಯಾ? ಶ್ರೀನಂದನ್
ವಿಜಯ್ ಕುಮಾರ್ ಮಗ.
ಏನ್ ಮಾಡ್ತಾರೆ ವಿಜಯ್ ಕುಮಾರ್ ಮಗ? ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಬಿಸಿನೆಸ್.
ಕೆಲಸ ಮಾಡಿ.
ಓಕೆ. ಶ್ಯಾಮಲಾ ಶ್ರೀನಿವಾಸ್ ಅವ್ರ ಮಗಳ, ನೀವೇ ಮಾಡ್ತೀರಿ? ಹೌಸ್ ವೈಫ್. ಏನು ಎಜುಕೇಶನ್ ಏನಾಗಿದೆ? PU ಆಗಿದೆ.
ಒಂದು 8 ಲಕ್ಷದ್ದು, ಇನ್ನೆರಡು 6 ಲಕ್ಷ.
8, 6,
ಒಂದು 8 ಲಕ್ಷದ್ದು, ಇನ್ನೆರಡು 6 ಲಕ್ಷ.
8, 6, 6.
ಹೌದು, 20 ಲಕ್ಷ. It is mentioned at para 3.
ಬರ್ಕೊಳ್ಳಿ. The suit in OS number 52/2012,
54.
54,
ಹೌದು.
54 of 2012, having been partly decreed,
Yes.
The judgment and decree were put in challenge by both the plaintiff side and the defendant side. Vide RFA 662 of 2016 connected with RFA crop number 6 of 2017. Full stop. Both the sides, with the active participation of their advocates, have settled the list one of the said petition being relevant or reproduced below. Of the said petition being relevant or reproduced below. Full stop. ಕೆಳಗಡೆ ಹಾಕೋಬೇಕು. In terms of compromise petition, the appellant A. Govindaraju,
Kamalamma and others.
Respondents ಅಲ್ಲ?
Respondent Govindaraju.
ಅಲ್ಲ, ಇದರಲ್ಲಿ RFA ದಲ್ಲಿ
ಅಲ್ಲಿ ಕಮಲಮ್ಮ and others are the appellants.
The appellants in RFA number 662 of 2016 this day have handed three bank drafts, demand drafts. One ಒಂದೇ data, all evenly dated
17/3/2025.
17/3/2025. Of them, one is for a sum of rupees 12 lakh, 8 lakh,
6 lakhs and 6
and
lakhs.
the other two
6 and 6.
are for a sum of rupees 6 lakh each, totaling to rupees 20 lakh. First off, we are of the considered view that there is no impediment on facts or in law for recording this compromise, which is apparently lawful, and thereby putting an end to the list in a wholesale way. First off, the impugned judgment and order are substituted by the compromise. First off, registry to draw the decree accordingly. First off, courts made easy.
Sale deed has to be set aside. Sale deed set aside ಆಗಬೇಕು.
ಅಲ್ಲೇ
60/1/2012.
ಕಾಂಪ್ರಮೈಸ್ ನಾಗ ಇದೆ ಅಲ್ಲ?
ಇದೆ ಬಟ್ ಅದು
the sale deed
dated 16/1/2012.
dated 16/1/2012 having been
para 4
set at naught, as has been stated in para 4 of the petition, compromise petition, the jurisdictional sub-registrar shall make an appropriate endorsement to that effect in his